We have that. We've got Virginia Unit 1, and I'm going to get out of the way.
Good morning from my perspective, Virginia, probably afternoon, your perspective. My name is Sue Leeson. I'm a senior judge on the Oregon Supreme Court. I'll let my colleagues introduce themselves.
Hi, I am Margot Lambert. I'm a professor of history at the University of Cincinnati Blue Ash College. And when you introduce yourselves, tell us where in Virginia you are from. I spent 5 years living in the District of Columbia, and enjoyed Alexandria quite a bit.
You're muted, Tandy.
And once again, I'm talking to a muted computer, to a dead microphone, but my name is Tandy McConnell. I was a professor of history at Columbia College in South Carolina for about 20 years, but then I decided to do something really important and I'm now teaching high school students very much like you. So it's great to be with you and looking forward to hearing your discussion.
And we would like to meet you.
Hello, we're Unit 1 from Maggie Walker in Richmond, Virginia. My name is Isabella Lee.
I'm Paige Walworth.
And my name is Ayush Patel, and I respond to as Mr. Olmschneider.
Terrific. I'm sure the suspense is killing you. We're doing question 2.
Oh boy. Sorry.
In what ways, if any, are the concepts of I just read you question 1. Now I've really got you confused. The foundation for good government is the rule of law. John Adams once wrote, "Good government is an empire of laws." How, if at all, is the rule of law embedded in our founding documents? What challenges to rule of law, if any, have we experienced in our history? And in what ways, if any, has the rule of law been important to the preservation of a free society? We look forward to hearing from you.
John Locke summed up the central idea of rule of law when he wrote that when law ends, tyranny begins. The Constitution is founded on the principle of rule of law, and the framers knew that government was only legitimate when it acted within constitutional limits. However, despite the foundational importance of rule of law to the American government, the principle has faced numerous challenges and is still undermined by abusive executive powers today.
The first and most important mechanism enforcing rule of law in America is the primacy of the Constitution, both over the federal and the state governments. First, Article 6 of the Constitution holds federal legislation above state decisions and both to the Constitution, ensuring fundamental American law is followed and protected. Madison defends and expands upon these constitutional provisions for this principle in the Federalist Papers, writing that even within rule of law, there is a hierarchy. Federalist 78 directly states that when any law conflicts with the Constitution ought to be preferred to the statute.
The second mechanism which reinforces rule of law in America is the importance of the common law tradition. The Magna Carta, signed in 1215, established protection against the government infringing upon a person's life or property except by lawful judgment and the law of the land. Several provisions of the British document are present in the American frame of government. Paragraph 34 of the Magna Carta, establishing the right of a free man to trial in his own Lord's court, is mirrored in the Sixth Amendment's right to trial by jury. John Adams expressly connects the Constitution to the Magna Carta, writing that the fundamentals of the Constitution of this province are stipulated in the Charter. This common law tradition ensures that rulings both bind and evolve with time and application.
The combination of a written constitutional system and common law means that the Supreme Court has often reinforced the rule of law in key decisions. In Marbury v. Madison, Marshall famously struck down the Judiciary Act of 1789, determining that it extended beyond the jurisdiction established by the Constitution. The act of Congress which attempted to modify the Constitution without the amendment process was thus unconstitutional. This landmark Supreme Court decision allows the judicial branch to enforce the rule of law through judicial review.
Rule of law preserves a free society by providing a mechanism to balance the will of the majority and the rights of the minority. Rule of law provides a balanced structure by which the will of the majority can be legitimately imposed and also places limits on that will. This means rule of law's role is particularly prominent in criminal prosecutions and laws dealing with unpopular minorities. For example, Batson v. Kentucky uses the 14th Amendment's Equal Protection Clause to prevent the state from unjust prosecution by limiting racial imbalance in jury selection. This ruling upholds the rule of law because it holds the Constitution to a higher ground than state interests.
Despite the vital importance of rule of law in our government, it is threatened when the president acts without legal sanction. For example, Article 2, Section 2 grants the executive the power to grant pardons. And while this has been used in beneficial ways, such as Jefferson's pardoning of those arrested under the Alien and Sedition Acts, The same power can render the executive branch susceptible to corruption and allow the president to bypass the judicial system, as seen with President Trump's controversial pardon of former Sheriff Arpaio. While the pardon power can be used for a variety of situations, the underlying presidential prerogative which enables it directly acts opposed to the fundamental rule of law system.
Similarly, executive orders, an implied power under Article 2, Section 3, permit the executive to operate outside of the legislature. For example, after the failure of the DREAM Act to pass in Congress, Obama issued an executive order implementing DACA, and Trump's 2017 travel ban was seen to be highly controversial due to both procedural and empowerment problems. Executive prerogative grants the president special privileges, which allows them to undermine the rule of law.
As Thomas Paine wrote in Common Sense, in America, the law is king, and he has been vindicated by the centrality of rule of law in our constitutional system. However, abuse of executive powers can hinder the effectiveness of rule of law, threatening one of our nation's most fundamental values.
Terrific. I'll start with a follow-up question that you made me really curious about. You start out by quoting John Locke, where law ends, tyranny begins. That same dude writes that the executive has the authority to exercise the prerogative power, the power of the executive to act above the law and even contrary to the law when the public good demands it, which then focuses the question on what is meant by the public good. How is that determined? Where do we draw the line between a discretionary exercise of executive power and an abuse of that power through the exercise of the prerogative? And maybe Locke gives us some clue. Let's start with him. Do you think he helps answer the question at all?
We admit that Locke is potentially confusing in his push for the executive prerogative. He does give an example with the pardon power. He says the pardon power is essential for two reasons. One, that the law might be unduly harsh and that clemency is required from the president. Second, that in the case that someone violates the rule of law for the common good, it is necessary for the president to be able to uphold that idea and allow people to be able to work for the good of the country and the good of the nation, even if it does technically go against the rule of law.
However, in contrast to Locke's beliefs, I think that the use of presidential prerogative, specifically that of presidential pardon, hasn't necessarily been used to uphold clemency and promote the common good, as stated by Locke. I think that if you look at examples such as Clinton's pardon of one of his cousins, the presidential pardon has actually mainly been used just to enforce or just to benefit the president's political allies rather than necessarily be used in the pursuance of the common good.
I really like that response. I want to add to that. So is there ever an example when a president, it's okay for the president to be above the law? You kind of implied here the pardon power, it's supposed to be, but it hasn't worked out that way. What historically, do you have any examples you could give me or that might argue for Locke and the executive's prerogative?
I believe we can look back historically to Jefferson's pardoning of those who were arrested under the Alien and Sedition Acts, in which the John Adams administration created those acts in order to limit any negative opinions by other colonists that would go against the federal government. If it wasn't for the pardon power in the first place, Jefferson would not have the constitutional power to be able to pardon those people, which we can see that the Alien and Sedition Acts could be classified as a violation of the First Amendment right to free speech, as well as right to assembly.
We also see during the Civil War, Lincoln greatly expanded executive power. He raised the militia, he blockaded ports, and used the pardon power extensively. And I think in that case, he was justified in expanding presidential prerogative and utilizing a great amount of that in order to protect the common good and to work towards unifying the nation again.
Is civil disobedience a threat to the rule of law, or does it support the rule of law?
Absolutely not. Civil disobedience is extremely important in order to uphold the rule of law in the first place. For example, we can look at the 14th Amendment Equal Protection Clause, and we've noticed an inadequacy of the 14th Amendment of being able to uphold itself depending on what the Supreme Court rules. For this, we can look at the 1896 ruling of Plessy v. Ferguson, in which the Supreme Court justified the separate but equal doctrine under the 14th Amendment Equal Protection Clause. However, it was due to the civil disobedience of prominent civil rights activists such as Martin Luther King Jr., who stated in the letter from Birmingham jail that it was the duty of the citizens in order to be able to have the ability of civil disobedience in order to reverse unjust decisions. And that's what we saw with, for example, Brown versus Board of Education. And we also saw that with the Civil Rights Act of 1964.
In contrast to my colleague, I think that civil disobedience can actually undermine the rule of law in some cases. For example, if we look at the January 6th events, while many people qualified that as civil disobedience, there was actually really no proof that the right electoral process was not followed in that. And so in that case, that act of civil disobedience was actually directly opposing the rule of law process.
I'm going to push you a little bit on that. At least according to your textbook, people who engage in civil disobedience do so with the understanding that they can and will be held accountable to the law. And that is what distinguishes them. They do it nonetheless for a higher purpose. And that is what distinguishes them from insurrectionists or simple criminals. Is it fair to say that what happened on January 6th was an act of civil disobedience in that respect? What was the higher principle behind the breaking into the Capitol?
I would argue that the January 6th event was not an example of civil disobedience. Instead, they were basing assumptions off of unclear actually reasoning there. We weren't complete. It wasn't an actual example of using, for example, the First Amendment right to petition the government or the First Amendment right to protest, but instead was a violent act which actually undermined the rule of law, as my colleague said.
I'm going to go ahead and disagree with my colleague there. Although I don't agree necessarily with the January 6th Capitol riot, I do believe that that was an exercise of civil disobedience, particularly because although my colleague brings up that there may be some sort of unclear reasoning, well, we can't simply tell that to the people who truly believe that the election was fraudulent. Those people, if they truly believe that the election was fraudulent, had a higher principle in being able to determine what was best for the democracy of this country. So although I don't agree with the riot, I believe that it was an act of civil disobedience and that it can be justified.
So then take it the next step. Rule of law is in conflict potentially with the principle of popular sovereignty. How do we balance those two principles?
I believe that we can balance. I believe we can balance those two principles by ensuring the fact that that just violating the rule of law or the right of rule of law itself doesn't necessarily always need to be absolute. There are times in which we can violate the rule of law if it is what the people want and if it's what the public good wishes for. On the flip side, if we were to completely always uphold the rule of law, then we wouldn't see a lot of the reforms that we would need in order to make America a more equal and diverse place, as I mentioned previously with the civil rights movement.
I mean, you're talking about the common good, the will of the people, and I love bringing popular sovereignty into this discussion. But what about, for example, when you get the Compromise of 1877 and suddenly the rule of law is not being obeyed in the southern states, and slavery is almost, it's not, slavery is gone, but the Black population is set back for almost another 100 years before they will get what they were seeking and had briefly during Reconstruction.
Right. So although that was a violation of rule of law, the violation of rule of law is not necessarily going to be always a beneficial thing or a negative thing. I believe from the Compromise of 1877, in which we saw the introduction, for example, of Black codes and Jim Crow laws, I believe that that was a negative consequence of violating the rule of law. However, we do see in certain cases that the violation of the rule of law can be particularly beneficial, which we saw later on in the civil rights movement.
So you go back to your opening statement. Where law ends, tyranny begins. For years, the US Supreme Court said the Jim Crow laws and the Black codes were just fine. So now I'm completely stumped. Does rule of law not give us a basis for judging whether laws are good or bad?
Well, the basis that rule of law gives us is that the basis that the Constitution establishes rule of law, although it's not explicitly defined, we can extract the implied power of Article 3 through judicial review. So inherently, whatever the Supreme Court decides is the rule of law, and that's truly problematic across American history, in which the Supreme Court has ruled wrongly on so many issues regarding equal rights that it's absolutely horrendous. I mean, we look at Korematsu versus United States, in which we saw the internment of Japanese Americans, but under the 14th Equal Protection Clause, as well as the common good under FDR's Executive Order 9056. I mean, I just don't believe that the rule of law necessarily always needs to be upheld, especially if it's harming those people.
While I would agree with my colleague that rule of law generally includes common law, I also look at the text of the 14th Amendment, which does require equality for all citizens. I do think that the Jim Crow laws and the Black codes in the South were definitely against that 14th Amendment.
We are out of time. Thank you so much.
Thank you so much. That was fun.
Yeah.
And now we know what you really are looking forward to is our feedback. Margot, would you like to start?
I will start. I want to say a wonderful grasp of American history. You covered the gamut. One slight little thing I want to mention about civil disobedience and the originator of that, Henry David Thoreau. I would argue, I guess, I loved your arguments for and trying to really be forthright and honest and fair to the people I would deem insurrectionists. But I would argue it wasn't civil. Their disobedience wasn't civil at all, and that would be one way to go with that. But I thought, again, you guys were quick and adept and skillful in your reasoning and your logic, even in that case. And I was very impressed. I just want to say great job, well done, terrific.
Thank you.
Thank you.
Tandy?
It was a very engaging conversation about some crucially important issues. I really liked your discussion of pardons. That yes, they can do enormous good and save people who have been wrongfully convicted or people convicted decades and decades ago, and so that their records can be expunged. But the danger that it might lead to corruption. I think we could probably say that while yes, there have been some notable cases where it was probably problematic, that for the vast majority of pardons that we never ever hear of are just very ordinary, making life better for ordinary people who become wrapped up in a judicial system where they may or may not be guilty, but the courts have at some point or the other overreacted. So I think that so it's important to think you really are bringing in both sides of a lot of cases here, and that's tough. I like the fact that you've argued with each other, so you're presenting us two sides. With Mr. Patel arguing for one side and Ms. Lee for another, and then Mrs. You can't read your last name there, sort of balancing in the middle. So we have a very nice picture here of the American political system with the three of you taking multiple sides there. That was great.
Yeah, I love the way you thought on your seats because you weren't on your feet. The way you were engaging with us as a real conversation and in dialogue with one another in a way that demonstrates a civil discourse, which is, of course, where we need to go to hold anything together. If I would push you anywhere, I think you need to have a little more of a definition of what rule of law is beyond the Lockean quote that it is when it ends, that's when tyranny begins. Because the concept of the rule of law as an aspiration or a principle or a goal is a little more complicated than that. The Constitution clearly allows for discretion. The question is, when is discretion abused? The pardoning power is not something that presidents has just come up with. It's a constitutional grant of authority. But what is the limit of that discretion? Now, I have a friend who was so upset with the way the pardoning power has been used that he is in the process of drafting a constitutional amendment to constrain the exercises of executive discretion. I would challenge you to do the same, because he's writing himself, he's just having the most interesting time with it and can't come up with how he wants to constrain the exercise of the pardon power, except interestingly, to throw it back into the Madisonian model, let the other branches, if they think the president has overstepped with respect to the exercise of the pardon, to place a check. Well, maybe that tells us what the rule of law in our thinking really is that it is a dynamic that Madison really had his hands on when he wrote Federalist 10 and Federalist 51. Just a thought. I think the real problem of prerogative power is powers that are not in the Constitution that an executive would assert in order to achieve the public good. For example, a wipeout earthquake in California, or we'll even make it happen in Virginia, where civil order basically collapsed because of an environmental disaster. Do we have to sit around and wait for Congress to pass laws and debate and so on? Or is that where we expect a chief executive step in and take bold action for the public good? Those are the kinds of things that I think this question would benefit from having your thoughts about, and might even strengthen your presentation. That was just a wonderful conversation, as was yesterday's. So thank you so much.
Thank you so much for your time.
Thank you so
Take
much.
care, guys.
You too.
You too.